Such an organized crowd. All right, so let me turn the presentation over to the chair. This is Professor Avedon Cover.
Good morning. I'm an associate director of the Institute for Global Security, Law, and Policy and an assistant professor of law here at Case Western. And I'm delighted to serve as the chair of the day's first panel, Presidential Power in a War Without End. This notion of an unending war is not just a fanciful concept dreamed up for academic symposia. We've seen these concerns evidenced in the Congress's application of sunset provisions, for example, in combination with greater powers that it has authorized for the president. Forever war has certainly been on the minds of the judiciary. In his opinion for the court in Boumediene versus Bush, Justice Kennedy observed that the relatively short periods of past wars had permitted the court to leave the outer boundaries of war powers undefined, but that the unending threats of terrorism could require clarification of the president's powers by the court. And to be sure, the executive branch has recognized the likelihood of forever war. Indeed, President Obama, with his eye on his current political opponent, even as early as 2009, is reported to have said, in contemplating the authorization of indefinite detention, that he had to think about how Mitt Romney could use that power. So the threats of terrorism are not going away. And what that means for presidential power, how we ensure accountability, how our constitutional structure is informed by and limits that power, and what is the role of international law in all figure in navigating the boundaries of presidential power in a war without end. We are fortunate to have with us a distinguished panel to lead us in discussion about these issues, some of which will hopefully follow on Jack Goldsmith's remarks earlier. Seated to my far right is Bahar Azmeh, the legal director and Center for Constitutional Rights, and a professor of law at Seton Hall University School of Law. Next to him is Sandy Hodgkinson, vice president and chief of staff of DRS Technologies, and a former assistant secretary of defense in the United States Department of Defense. Next to her is Associate Dean Jonathan Enton, and professor of law and political science here at Case Western Reserve University. And finally, Professor Jeremy Rabkin, professor of law at the George Mason University School of Law. Each panelist here will speak for about 10 to 15 minutes, and then we will open this panel to discussions. Professor Azmeh?
Okay, thank you, Avi, and Michael and the Cox Center for inviting me here. I thought since I'm starting, I'd focus my remarks on Professor Goldsmith's book, both because I think it's an incredibly thorough and thoughtful and readable account of the post-9/11 legal and political dynamics, but also because my organization, the Center for Constitutional Rights, Professor Goldsmith features fairly prominently, along with other human rights NGOs, in his account of the accountable presidency as one of a variety of somewhat novel checking mechanisms on presidential power. And I think his account of our role we're somewhat ambivalent about, because on the one hand, I think it largely endorses the initial work that human rights organizations did to challenge some of the excesses of the early years of the Bush administration, in particular CCR. Filed the first set of habeas petitions challenging incommunicado detention in a secret prison in Guantanamo, which led to the recognition of some fundamental rights for detainees. But on the other hand, I think Professor Goldsmith identifies a set of unintended consequences of that work, which is that we've largely helped to, by pushing sort of for legal accountability, ultimately legitimated some of the policies that we're deeply critical of. For example, military preventative detention, military commissions, targeted killing, and that's a sort of paradox that has a bit of sting to it, because of course no human rights lawyer wants to hear that their work has legitimated a system they've designed to attack. I want to use my time to sort of focus on two parts of his analysis. And I should say I largely agree with much of the description of the post 9/11 legal landscape. But I also take Professor Goldsmith's book to have a sort of normative gloss to it as well. That is, I think he largely endorses the current state of national security affairs, and I suspect that's where he and I differ. So I want to sort of address the claim of legitimacy, the idea that we have a political and legal consensus around detention and targeting policy that is that is normatively valid or normatively good, and second, his ultimate claim that we have a system of meaningful accountability that is durable in as we enter this sort of endless war, which I think is only partly true or turns on one's definition of accountability, and I would endorse a different one. So first, let me start with the argument about legitimacy. I think, as we saw, Professor Goldsmith believes that there's largely a legal and political consensus that is undergirded a current detention and targeting and military commission practices, that the public and the presidency and the courts have largely endorsed the policies that have undertaken by the administration, and I'll sort of want to look at some of the actors there and test this theory a little bit. First, the presidency. Professor Goldsmith is certainly right that Obama has continued many of the sort of second generation Bush administration practices, and that the Bush administration itself has rejected so many of the practices that Obama criticized on the campaign, torture, rendition, black sites, but has endorsed things like military detention, military commissions, and targeted killing. And in the latter category has expanded them dramatically. I took Professor Goldsmith's book to say that part of the reason Obama has endorsed those practices is that they have been vetted by lawyers and tested, and therefore have a sort of legal legitimacy to them, and so his endorsement is somewhat principled. And there, I think that's contestable, because I think happenstance and political pressure, all of it not necessarily ennobling, has put him in this situation. So take detention policy. It's true he's abandoned his decision to close Guantanamo and try 9/11 conspirators in the courts. But I think a lot of that has been driven by, I think, unfair and sometimes irrational congressional reaction and political grandstanding, a sort of NIMBY politics that would prevent, for example, the resettlement of conceitedly innocent Uyghur detainees in the United States, that I think would have profoundly changed the dynamic about who is at Guantanamo and whether or not they can still be considered dangerous. Or the trial of 9/11 conspirators in the Southern District of New York, an objection I can't particularly get my head around, and I think calls into question the two accounts of legitimacy. I mean, I think it's far more legitimate to be trying them in criminal courts than military commissions, and even the resettlement, congressional limits on the resettlement of detainees abroad, which has dramatically limited his ability to close Guantanamo, as half the detainees currently there have been cleared for transfer but face restrictions that Congress sought not to impose on the presidency. And at the same time, I think there are sort of narrow political priorities that changed when he entered office. If you read Daniel Klaidman's account, Kill or Capture, that we have an ambivalent president who's pushed on, the sort of devil on one shoulder and an angel on another, the devil being Emmanuel and Axelrod, and the angel being Greg Craig, and it's the political operatives who are telling him it's crazy to advocate for detainees when you're dealing with a financial crisis and health care. And so it seems to me that it's sort of as much narrow politics as law that has been has driven these decisions, and as such, I think lends less sort of legitimacy in an objective sense than there otherwise would be, or take the president's decision not to go after CIA officials for torture and homicide of detainees. That could be, as Professor Goldsmith suggests, a sort of political consensus around what is wise to do in looking backwards versus forward. It could be also, as Jane Mayer recently suggested, she talked to I think it's a high-level Obama administration official who apparently warned the president early on the worst thing an inexperienced, especially Democratic president can do is to sort of, in their view, sell out the CIA because they will make his presidency incredibly hard. And that, to me, is sort of an uncomfortable picture of legitimacy. And certainly the CIA has more scrutiny than it had in the past when it would, freewheelingly undermine Presidents Eisenhower or Johnson. But I think we should be concerned about an entity that has so much independence and leverage, and I think not subject to meaningful scrutiny. A second feature of legitimacy is the public, and it's certainly true, and I think Professor Goldsmith cites some public opinion polls that suggest the public generally endorses Obama's policies in those areas. I think largely because of the sort of reverse Nixon goes to China account that he offers. It's a Democratic president looking tough. That's good. But I think it can be more attributable to sort of apathy than genuine sort of affirmative approbation of these policies or other priorities like a bad economy. I recall a colleague of mine last year said, he was approached by someone in a cocktail party, a colleague of mine who works on Guantanamo cases, by a fairly sophisticated person who said, wait, I thought Guantanamo was already closed. So there's a sort of a question of how much people are genuinely engaged, and also a question of whether or not, public opinion should be a way, a metric to measure accountability, because you can think of something like Korematsu or Jim Crow that was endorsed by the very same apparatus of institutions of government and the public that over time did not have legitimacy. And then think about the courts. I think Professor Goldsmith, as I did at the time, endorses the Supreme Court's decision in Boumediene, which guaranteed a constitutional right for detainees to access courts to challenge the legality, the factual and legal basis of their detention. And that's important because as the district courts were hearing these cases, they were genuinely, I think, checking the executive branch. They're for the first time imposing a substantive limits on the detention, who can be detained. They were excluding evidence obtained by torture in a court of law. They were really carefully scrutinizing the evidence and holding the government to their claims. And so that strikes me as what would have been a legitimate system of checks and balances. But I don't think Boumediene is the law of the land anymore. I think, as some of you may know, in my view, the D.C. Circuit Court of Appeals has effectively overruled Boumediene, and some numbers of the courts have sort of mocked it as full of airy suppositions. And in a series of cases, basically they've reversed every grant of habeas by a district court, affirmed every denial of habeas by a district court, and I think simply have ratified every executive detention decision, accepting the legitimacy of the government's evidence. And so the Boumediene is gone, and we have a court system that, in my view, particularly since most of these cases are located in the D.C. Circuit, is far too deferential of the executive branch. So on the question of accountability, I think Professor Goldsmith has a particular theory of accountability, one that's sort of rooted in political accountability, that is transparency, that people are forced to explain their actions to the public and other institutions of government, and that causes changes in behavior. And I think it's a forward-looking theory of accountability, but I think it misses another important feature of accountability, which is imposing legal sanction or legal consequences to past illegal conduct. And I think it's regrettable that our institutions have refused to do that. I'm not as pleased. I'm not pleased with the high-level DOJ officials' decision to overturn ethics reprimand of the architects of the CIA torture program, John Yoo and Jay Bybee. I don't think that's sort of meaningful accountability, or the failure to meaningfully investigate the CIA. And also there are these, Boumediene may be a sort of a high point of judicial checks on the administration, but I think there are a series of cases that establish, in my view, a sort of architecture of impunity for high-level government officials who have engaged in some of the worst practices: rendition, torture, racial discrimination. And I think that's particularly regrettable as, I think in a system of, in our Marbury paradigm, awarding damages or holding individuals accountable under law is a part of the rule of law. And other countries have awarded damages to the very same individuals who were denied redress in U.S. Courts. I think that's a significant chink in the account of accountability. And I would just sort of end. I mentioned that there was a sort of a paradox about the role of human rights organizations. And I, having legitimated the system, I worry about another, I think, potentially more tragic irony here, which is that to the extent that, again, this is, from my perspective, we're contorting our legal traditions to endorse things like indefinite military detention, the detention and bombing of hundreds of individuals, primarily Muslims, in a variety of countries, in a manner that seems deeply illegitimate to other nations. And I think ultimately to history, and that we would do that in order to sort of expand our national security powers, I think risks making an attack even more likely over the long term. And I think that's a sort of a tragic possible outcome. Thank you.
Thank you, Bahar. Sandy?
Okay, so I will pick up from here. I'll start a little bit. First, I have to demote myself a little bit. I'm actually a former Deputy Assistant Secretary of Defense. Not that it means much to most people out in the academic world, but in that last role, I actually was responsible for overseeing detention affairs at the Pentagon, both in the bridge from the last couple years of the Bush administration into the Obama administration. I was a career U.S. government official for a lot of years until earlier this year, between the Navy JAG Corps, the State Department, the Defense Department, the National Security Staff, all wrapped up about 16 and a half years just earlier this year doing that. And for the last 6 or 7 of those years, I was directly involved in oversight for the detention policies. I mean, I started at the State Department when I came back from Iraq, when we were sort of, how do you deal with the post-Abu Ghraib environment? So I was sent over to the National Security Staff, where the NSC staff, as it used to be called, now the NSS staff, where I was allowed to then help John Bellinger and then take over the Policy Coordinating Committee, as they used to call them, that handled detainee affairs. I was brought back to the State Department to be the deputy to the War Crimes Ambassador when they put detainee affairs in the War Crimes Office, and ultimately over to the Pentagon to be the senior official on detainee affairs. So I watched a lot of those evolutions through the Bush administration, worked on them from inside. And then in the Obama administration, I stayed on as a career official, which is what I've always been, and served as the Chief of Staff to the Deputy Secretary of Defense, which was the senior place in the Pentagon where detainee issues came. So everywhere I turned, it seemed they just kept coming back. The longer Guantanamo stayed open, I still had it. And the good news is I've lived to tell about it. So I really enjoyed hearing Professor Goldsmith's presentation because, I've read parts of the book, not all of it. But I, for the most part, agree entirely with the premises he makes. So some of the comments I'll make, I'll try not to be repetitive and really try to key off on areas where I might bring up some different points he may or may not agree with, and then move on to some other issues as well. First, I just have to sort of use one of the quotes that I found kind of interesting to me as a person who lived through this, which is this quote, this notion that, the Congress and courts pushed back harder against the presidency for the Bush counterterrorism policies than in previous wars in the process of vetting, altering, and ultimately blessing his core counterterrorism policies. every time I hear the word blessing and I think back to what I endured in all of those jobs, it was clearly a blessing in disguise. Because I never felt as though anyone sort of blessed us, thanked us for the hard work, said, good job, now go out and do something different. It always seemed like everything you tried to fix, you get attacked from the outside about a new issue. And so every now and then, you always like to stop as a government person and say, hey, where's my pat on the back? But they didn't really come in this field, and obviously that's not the reason why people serve. So anyway, I had to comment on that. But for the most part, like I said, I agree with the premises that he made and the statements that he made. A couple areas that I would expand a little bit on is, so, how do you get to a point where 2008, both the Democratic and the presidential nominees were going to close Guantanamo Bay? How do you get to a point where we're in another presidential election and it hadn't happened? And Congress is one reason we'll get back to, but there are other reasons too. And so, Professor Goldsmith mentioned the Common Article 3, the habeas, the military commissions improvements, the Detainee Treatment Act, all of which I think were important changes that were evolved under the Bush administration. I would also talk a little bit about, though, there was a strong role that was put into working with key allies. And so working with allies in other countries who were also working on trying to fight this new threat and trying to find commonalities between them. And in the early days, it wasn't exactly a love fest. But as time went on, we found more common areas with other countries facing similar challenges. And I think that was something that sort of helped evolve the process as well. I'd also sort of look at the fact of where you were at when Obama took over, which is that more than 2/3 of the detainee population from Guantanamo Bay had already been released. They had been released or transferred through the combatant status review tribunals or through the administrative review boards or other review processes. And a lot of times you would hear during the campaign and other times, boy, those are all sham procedures, none of the procedures put in place are any good. But I would challenge the proposition that a procedure that lets more than 2/3 of the people out over a finite time period is actually, in an ongoing war, is actually a pretty decent effort at trying to do that. In fact, to the contrary, I'd look at the fact that many of them actually ultimately went back to the fight. And so the fact that people who had been transferred or released went back to the fight, an issue which the Bush administration has been heavily criticized for, actually in some ways legitimized the notion that the people you were holding at Guantanamo Bay were actually dangerous. It countered the earlier proposition that a bunch of innocent goat herders sort of got rounded up on the battlefield in Afghanistan and swept off to a place where no laws applied. So that issue of recidivism has sort of come back in a different way to legitimize the process in saying that these are some high-threat individuals. I'd also point out, Professor Goldsmith talked a bit about the politicals who were involved and that key political officials were kept on from the Bush time until the Obama time. I'd also point out that, at the next level down, the career officials in a lot of places played a fairly key role, and not just in the fact that they had, vested themselves in these policies over evolving them over time, but the fact that if you have the same intelligence officer looking over and over again at a guy they've determined to be a high-threat person, that doesn't really change, no matter who the political leader in charge is. And so career officials at a lower level were significantly vested with decisions and determinations they'd made about threat levels, and that obviously changed the character of we got to release or transfer all of these individuals into only one solution if you were going to close Guantanamo, which meant you had to move them to the United States. You couldn't move them back to the battlefield once habeas attached. The courts wouldn't allow it. And you couldn't send them all back home. So once you were left with that proposition, there was only one choice. It was a one-way ticket to the U.S., which later had other problems. I'd also, give a little bit of credit to some of the other colleagues I worked with in the Bush administration who were political officials, who worked very hard on the inside to make some of these very difficult changes. I look at people like John Bellinger and Matt Waxman and Pierre Prosper, who I worked with, who really did work hard. It wasn't just external factors. A lot of it was also internal actors who wanted to help get the policies in a more legitimate place. They had their own reasons, maybe for political reasons or others. One of the principles I always carried with me was this notion that you cannot have an executive branch authority that does not include the ability to detain people in wartime. You cannot have a policy that requires you to kill over capture, a no-quarter policy, as we call them. I mean, I first started out in the Navy JAG Corps. I still work on law of war issues with the Navy in my reserve capacity. And it's a critical part of having a military that's ready to fight. And so, one of the motivators I always had wasn't political, because I was apolitical in my role, but it was to look at how do we keep something that we need to maintain and have for the future, a durable detention policy. And to do that, you need to make changes. So I want to make a couple other points on this notion here of, executive authority in a war without end. And a couple of the points that I'd like to make is that I worry a little bit about the 11-year evolutionary process to get to an endorsement in wartime of detention authority. I worry that that does erode executive authority, which obviously puts you in a position where the administration that most wanted to enhance it, at least rhetorically, put us in a position where maybe we lost as much executive authority as we, or more than we should have. But some of it's not just about the decisions that were made. I think some of it stems from the national security structure and the process that we use within the government to try to make decisions. For those of you who don't know it, it's just going to sound like a bunch of acronyms, so I'll try to make it pretty easy. But basically, every agency has representatives they send to an interagency meeting over at the White House that is coordinated by someone like me who brings everyone in and tries to get everybody to agree. And we bring it up to the next level called the Deputies Committee, which is the deputy cabinet members. And then they're supposed to decide on hard issues. And if occasionally there's something that's split, they're supposed to send it up to the principals, the cabinet, for the president to make a decision. So you look at the two areas that Professor Goldsmith spoke about, when you look at Guantanamo closure and Article 3 courts and why we didn't bring detainees into Article 3 courts. I mean, those are areas where, in my view, certainly the executive needed to act decisively. I mean, you needed to make a decision early on. Obama needed to move those detainees into the United States before there was an opportunity for Congress to sort of build up all the space in opposition. I mean, as they found through the review process, the Obama administration, same career bureaucrats who worked on it under the Bush ones, would come up with the same basic results on each detainee. So taking a year to re-review everybody lost political space at a time when the executive needed to be decisive. The same thing happened with the Article 3 courts. I mean, from the moment of announcing that you're going to take Khalid Sheikh Mohammed into the United States for a trial to the moment when, 12, 14 months later, you ended up saying, well, maybe we're not going to do that. We'll leave him at Guantanamo, where he was still physically anyway, and bring him back to military commissions. Unfortunately, that failure to be decisive is where I think you also lost space. It wasn't just that Congress was opposing things. Congress was given the opportunity to build up political space and opposition, and that's what happens on these highly critical issues. But the structure itself, this deputies committee level structure, I would argue in both the Bush and Obama administrations, has not been well suited to handle this issue, because a lot of leaders have been not willing to take on hard decisions in an area where they're being so criticized from the outside. So every time you would, working in the interagency committee, you would tee up a decision for the deputies, and most of the time they'd send you back to do more staff work. I mean, because taking a hard decision is hard to do. And not enough senior leaders have been willing on these hard issues to send up really difficult issues for a final decision by the president, because there's always somebody worrying about how is this going to play politically, what are the external factors going to say, what are the lawyers groups going to say, what is academia going to say, NGOs, the courts. And so all these external factors have, unfortunately, in my view, left us in an area where we're a little more paralyzed. One last thing I'd like to just mention during my time, because we'll have time during questions, is I do want to talk for a minute about this notion of us being in a war without end. Because from the beginning, I've challenged that proposition in every job that I've had. Because, I don't think there really are wars without end. I mean, almost any war has an achievable end and an objective. And when I would say this 6 years ago, people would think, that I obviously had been doing detainee affairs too long and had lost my sense. But I do think that there's always been a possible path to victory, and I think we're frankly getting closer to it than ever before. And that path to victory includes killing or capturing the senior leadership of Al-Qaeda, which is why capture is an important tool to have. Detention is an important tool to have alongside with the kill policies, and they'll be talked about in another panel. In a conflict, you have to have that ability. You've had it in every war historically, you need to have it now. and executives need to have all of the tools at their disposal, not just the most popular ones. Second, you need to cut off their methods of travel, and we've been doing that very efficiently by working with other countries to try to cut off the way that the terrorists have been traveling over time. I think we've made gains. I would argue that we have cut off funding sources to a large degree by not only naming and shaming, but by trying to actually stop and criminalize certain activities of supporting terrorism. And while also at the same time looking at these other methods of winning the peace in other ways, which our military strategies have tried to deal better with insurgencies. But there have always been elements, even after a conflict, where there are elements of insurgents or others in society who don't listen necessarily to the peacemaker who said end of the conflict. And you're still going to have that here. So, I still believe that this is a war that actually can have an end, and that's what the president needs to focus on. And then, assuming that it does have an end, though, I'll throw out a proposition that I've often been challenged on. Assuming it does have an end, it becomes extremely important at the moment that the war ends with respect to any group or particular group that the detainees that are still being held are released, and that there's an orderly transition of them out of military detention unless they're separately charged with another crime and tried for those crimes. And it does become a little difficult when, Professor Goldsmith spoke a little bit about this notion of the authorization for use of military force and whether or not the terrorist groups have shifted and morphed enough over time to not necessarily be neatly defined as they were post 9/11. I think that's happened, certainly, but we need to be sure, for example, if the Taliban made peace, Taliban detainees theoretically should be released. You can't necessarily hold on to everybody that was part of the original conflict until the last person lays down their weapons. Because if you set that precedent, then you will always have trouble making peace, recognizing there can always be an insurgency at the end of any conflict. So I think that those are a couple points I wanted to raise. I know a lot of people have argued we need to continue to hold people under security threat after the war ends. And I think unless you have a structured security way to do that, that's structured with the courts and otherwise, then you really can't do it. It's military detention ends when the conflict ends. Okay, I'll stop for now.
Thank you, Sandy. We'll now hear from Jeremy Rapkin.
Is it the title of our panel that's Executive Authority in a World Without End, or the whole conference? Just our panel. Our panel. Executive Authority in a War Without End. I think of it as executive authority in law without end, or executive authority in legal disputes without end. And I want to start by saying one reason why these disputes don't end is we change our positions depending on who is in office. Jack Goldsmith this morning was acknowledging that Obama can get away with things that Bush couldn't, and I thought that was a great part of his speech. I wish there was more of that in his book, which is otherwise a really great book, but is a little bit too inclined to pretend that we've come to rest at an equilibrium which will go on, whereas what strikes me as a former political scientist is really how partisan the reactions are and how different they are in one administration and the next. Let me give you a couple of examples. Last night, some of you may have seen speeches at the Democratic National Convention, and there was Vice President Biden saying, Osama bin Laden, he's dead. He's really dead. We killed him. That was justice. We did justice. We killed him. It was justice. It was great. And everyone's going, yes, yes, yes. If Bush had, at one of his appearances, said, we killed him, it was great, let's all cheer, it's possible Republicans would have cheered, but the New York Times would have gone crazy. It didn't go crazy this morning because it's okay if you're Obama. The killing of Mr. Awlaki, an American citizen, and what did he do, right? We killed him by a cruise missile strike in Yemen, I think, right? And what did he do? Clerical malpractice. Bad spiritual advice. I mean, he wasn't planning operations. He was not really a combatant. I don't feel sorry for him. It's okay with me. If anyone asked me, I would have said, get them all. But if this had happened under Bush, people would have gone crazy. Under Obama, the answer was, no, 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 don't worry, there's a process. When the president orders American citizens to be killed, it doesn't just happen. I mean, there's a process. And everyone said, oh, well, okay, there's a process. Well, then, fine. It's secret, it's entirely within the executive, and it's unreviewable. But never mind, it's a process. Okay, then, a process. Well, that's good. Consider the leak, which we had a few weeks back. New York Times tells us, and the reporter has a whole book about here's how the SEALs went in there and got Osama. That was not meant to be a joke. Everyone does that. I'm sorry. How they got Osama bin Laden, here's what and here's what happened in the White House, and here's someone who talked to the president who said, and by the way, there was these cyber attacks on the Iranian nuclear program, and in the White House they said, and the president said, and in meetings they said. There was an unbelievable amount of detail about very sensitive things. The Secretary of Defense said, shut up, this is terrible. We know that other people expressed a lot of concern within the administration. I personally think the whole cyber thing, which I've been trying to write about, well, you're not supposed to just put that all out there like that. And everyone said, oh, well, and they moved on. Now compare that to Valerie Plame. Remember Valerie Plame? We were all in a tizzy because somebody who was married to somebody had been mentioned in a column, and we had an independent counsel. And this went on for years and years and years, and was outrage because the Bush White House had outed a CIA agent who happened to be living safely in Washington. But even so, she might have visited a foreign country, and this could be dangerous. Hysteria and an independent counsel. And in the Obama era, it doesn't matter. Now, I agree a lot with what Jack Goldsmith said, that this has something to do with expectations and whether it's against type and so on. I liked his formula. Some people trust the policy, some people trust the president. But I think that is a little abstract, and particularly for this kind of discussion, we should go down a little bit more. What seems to me is there is a community of international law advocates and civil liberties advocates who are well represented here. People who take this really seriously and think it's really important, and more important than passing transient American security interests. And Democrats and the media embrace them against a Republican president and forget them, whatever they're saying, against a Democratic president. So there was a lot of amplification of CCR objections against Bush. No one's interviewing you that much these days. I don't see you guys quoted very much these days. Now, I don't mean to be indignant about this. I just want to get everyone to focus on this. I totally agree with Mr. Asmay on this. What Jack Goldsmith is describing, and I think even Jack Goldsmith wouldn't deny this, is not really we have come to a set of legal formulas which we now agree, and they've been tested, and now we know they're the law. That isn't really what he's describing. I believe, certainly in his book, what he's describing is we came to a political equilibrium. And if I have a difference with him, I don't think it's very stable. I think if there is a Romney administration, you guys will be back in business, because the media will be very interested again in international law. What about international law? We forgot that over the past 4 years. That's important. The Constitution, that's important. We'll come back to all those things. So I think it's political equilibrium. It's not very much law in the sense of established norms. Having said all that, I do want to acknowledge I used to be a political scientist, and I want to go back to politics and say, particularly regarding international law, but also I think regarding constitutional law. And here I do want to commend to you not only Jack Goldsmith's excellent book, but his really very, very intriguing and provocative and thoughtful and serious article in the Harvard Law Review a few years ago about law for states with Darrell Levinson, in which he makes this point. There's a lot of things that people say about international law that it isn't really law, which you could say as well about many areas of constitutional law that they're not very well settled and they don't apply very reliable rules in a reliable way. Yes, 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 all excellent points. And I want to, just in a few minutes here, say, if you step back and look at what it is we are talking about, a lot of these security debates are things which, it seems to me, international law cannot expect to deal with in very firm, clear, reliable rules. We have international norms to the extent that we do. because countries say, yes, I agree with that in general, but not exactly or in particular. Many of you may recall the International Court of Justice in the Nicaragua case. They were called on to interpret customary international law, and the American objection, apart from all these jurisdictional objections, which were serious, was everyone disagrees, there's no law. And they said, no, it's true that most countries they follow their own version of it, but every time a country deviates from customary international norms, it says our case is different. Saying your case is different is saying that in general you accept it, and so the important thing is in general you accept it and not in the particular it doesn't apply to you. I don't think that is completely ridiculous. I think that actually does capture something serious, putting aside whether it leaves you a law that the ICJ should be enforcing. And I think it's true with a lot of these disputes that we are having. You only will get the norm if you acknowledge, maybe not in a loud voice, that there's going to be some deviations in the way it is applied, or there's going to be dispute about the way it is applied. So let me just give you a couple of examples that seem to me relevant to this, which I do think go back to executive authority, particularly in wartime, war without end, but any kind of ongoing security disputes. The Libya intervention. The Obama administration decided it didn't need approval from Congress. What it needed was approval from the Security Council. And the Office of Legal Counsel prepared this memorandum in which it explained, well, the president has this authority because the war is going to be over right away and we're not really going to be involved, and it's part of the president's, somehow related to his constitutional authority to help forward the purposes of the United Nations. I thought that was kind of amazing. And then, of course, what happened was the war wasn't brief. Our involvement wasn't so minor. A lot of people got killed, not a lot, but some people got killed because of American bombing, and it went on for 6-7 months, so it wasn't quite what it was sold to be. And the authorization from the Security Council was to protect civilians. And it's pretty clear that isn't really what we were doing. We were overthrowing a government, which had not been authorized by the Security Council. Now, I don't mean to say, ha, gotcha, you violated international law. I mean to say something different, which is, the interesting thing is when that whole episode was over, everyone could have a different view of what did it show. Was it a precedent that you can act however you like when you get a UN Security Council authorization? I don't think so. Maybe it's a precedent for you can go a little bit beyond the precise terms of the Security Council authorization. I mean, maybe it shows the Congress will allow you to go forward. But actually, if you look at this realistically, what happened was there were a lot of arguments potentially in play. And when it was all over, there were a lot of arguments potentially in play for the next round. Jack Goldsmith gave this excellent example in his talk this morning about prosecution, which I think is a really good point about prosecuting people in the Bush administration for encouraging abusive interrogation practices, which some people think are torture. Yes, okay. And he said, if you had the prosecution, this might actually have ended up giving a kind of validity to the things that went on. Not having the prosecution allows a lot of different arguments to be there. It seems like the prevailing mood is, no, that was really wrong, but we haven't had an authoritative determination one way or the other, so a lot of arguments are in play. I would say this is true for the UN. I would say it is also true for the American Congress. People in the American Congress didn't make a big fuss about Libya. We can dispute about why that was. What we can't say is definitively, you can't bring up objections against President Romney or whoever it might be in the future because you didn't bring them up there. That isn't the way it works. There are a whole set of associations, notions, arguments in play. We don't know for sure exactly what work they do or how they would apply. I don't think that is a bad thing. And in any case, I think you're not going to do better than that in international law. And I think on many cognate constitutional issues, you're probably not going to do better. And if you then realize, okay, this is not going to be law like the Internal Revenue Code, it's maybe not a bad thing that we keep a lot of arguments in play. Let me give you just one more example, since we have limited time, which some of you will like and some of you will not like, but it's my job to tell the truth. The International Criminal Court, for people who really like criminal accountability, because that is real accountability, that is real law, yeah. Let's just remind ourselves, they've been out there for 10 years, they've hardly done anything, and I would say the kind of condition for their existing is that they be very, very careful how they actually enforce their law. I have heard people say, if they do prosecute an Israeli, that will be the end. I hope it may be so. But I am not confident of that. I am confident if they prosecute somebody from Britain or France, that will be the end, and they know that, especially someone from Britain or France in a UN peacekeeping operation. You can have international criminal justice as long as you understand that you don't really have international criminal justice, meaning it's totally on autopilot and there are no limits and it can do whatever it wants. And I would say that is likely to be so with presidential authority in, what is it, a war without end. There's certain politically defined and therefore shifting limits on the president. You shouldn't expect reliable law of the kind that I'm told by colleagues restrains the IRS, although that could be wrong. Thank you.
Thank you, Jeremy. And finally, we have Jonathan Enton.
Okay, thank you, Avi. I am a law professor, mostly, and at the risk of inflicting what might be viewed as a mosquito bite on Nat's eyelash, I actually want to talk a little bit about law as we sometimes think about it conventionally. And to this end, I want to make 2 points. The first is that courts are not likely to play a large role in resolving a lot of these issues. I don't mean to say that courts will play no role. Indeed, courts have already played some role. But I think in the grand scheme of things, as Professor Goldsmith's keynote address and as most of the comments so far have suggested, courts probably aren't going to play a predominant role in resolving some of these issues. And the second point that I want to make, perhaps with somewhat less confidence, is that that's probably a good thing. But let me start with the notion that courts are unlikely to play a large role here. It is true, historically, that we can point to some landmark judicial rulings in national security type situations. There's a kind of familiar historical litany, the steel seizure case, for example, the Pentagon Papers, the Iranian hostage case, Dames and Moore against Reagan. Those of us who do First Amendment start pretty much with a whole series of cases that arise under the Espionage Act during the First World War. And of course, we've heard appropriately some discussion about Boumediene and some of the more recent cases that speak to contemporary issues. I want to come back to those, but I want to suggest initially that we shouldn't expect a huge number of cases actually to work out some of these issues because, first of all, there are lots of procedural and jurisdictional obstacles to getting these cases teed up for a court to resolve. One pretty obvious problem is standing. Lots of people may not like what President Bush or President Obama or President whoever is doing, but under conventional standing doctrine, courts don't, U.S. federal courts do not give advisory opinions, and any ordinary citizen who may be unhappy about public policy has a generalized grievance and therefore won't have standing to sue. Now, how far we can push this, we may find out a little bit later this term. The Supreme Court has on its docket this term a case called Clapper against Amnesty International, which involves a challenge to the surveillance program that was authorized by the Foreign Intelligence Surveillance Act amendments of several years ago. The only issue in the Supreme Court at this point is whether Amnesty International and the other NGOs and suspected targets of this surveillance, whether they have standing. So we'll see how that one plays out. It's possible that members of Congress who don't like what the president is doing might go to court. Well, at one time that seemed like a more plausible option, but back in the late 90s in Reigns against Byrd, the Supreme Court told us that ordinarily members of Congress do not have standing to sue over executive action. Now, Reigns against Byrd involved a technical budget issue, but shortly after that, in the wake of President Clinton's dispatch of military resources to the former Yugoslavia, a group of members of Congress sued, claiming that the president had acted beyond his lawful authority. And in Campbell against Clinton, the D.C. Circuit concluded that the plaintiffs did not have standing as members of Congress. Now, this was a three-judge panel, and the three judges managed among them to produce 4 opinions. So precisely why these members lacked standing may not be entirely clear, but nevertheless, it is true that it's going to be pretty difficult for members of Congress to challenge some of these actions. It is there's another set of obstacles. It is possible, I think it is less likely, but it is possible that some challenges might be resisted on the basis that the issues presented are non-justiciable political questions. There's some question about whether we even have a coherent political question doctrine. And whatever that doctrine means, courts have tended to hesitate to apply it in modern times. But there are, in fact, a number of cases where challenges to executive policies in the military and foreign affairs area have been dismissed on justiciability grounds. So at least we ought to think about that possibility. There are also some timing issues that might might come up, and Professor Azmi can explain that. I think that skillful lawyers may be able to try to craft some challenges to avoid these, but there are some precedents. There's a challenge to Operation Desert Storm, the first Gulf War, that was brought actually by some members of Congress. The case is called Dellums against Bush, and this is a pre-Reigns against Byrd case, where the district court concluded that Congressman Dellums had standing, but also concluded that his complaint was not ripe because Congress itself had not yet acted, and so he was effectively in court too soon. And then there's another timeliness issue. There's a potential mootness issue that's illustrated by a case arising out of President Reagan's policies in Central America. Barnes against Klein challenged these policies, or some of these policies, as violating a congressional appropriations rider. By the time the case was decided, the court concluded that the rider had been for only one fiscal year. The fiscal year had ended. The case is moot. Okay. So we've got a series of these sorts of procedural and jurisdictional obstacles. But it's not impossible to structure challenges. Clearly, if you're a detainee, for example, you're going to be able to meet some of these challenges. But even if you get over the hurdles of standing and justiciability and timing, there's also the problem of what happens on the merits when the courts review your claims. Now, it is true that cases like Hamdan and Boumediene suggest that the Supreme Court has shown less deference to the executive in modern times than it might have done in past periods of conflict, at least while the hostilities were underway. But as Professor Osme pointed out, lower courts have generally taken a pretty skeptical view of the claims on the merits. As he says, the D.C. Circuit has overturned just about every ruling that a district court has entered in favor of detainees. There are other cases involving extraordinary rendition where other courts, the Second Circuit in Arar against Ashcroft, the Ninth Circuit in Mohammed against Jefferson Data Plan, for example, have addressed the merits and rejected the claims on the merits. In all of these cases, whenever Supreme Court review has been sought, the court has denied certiorari. So on the merits, it may be an uphill battle in a lot of these cases. Now, let me turn to my second point, that this is probably a good thing, given the quality of political discourse these days. I'm not as confident about the normative claim I'm making here as I would like to be, but nevertheless, let me suggest that this probably is a good thing that these issues are thrashed out largely in the political arena. One reason that I think this is a good thing is just something about the dynamics of the litigation process. It takes a long time to get a case resolved. I mean, okay, the Pentagon Papers case went from the publication of the first article to the Supreme Court decision in about 2.5 weeks, but that's about the only time we can think about it. Let me use another sort of canonical constitutional law case to give you a sense about why I think that the litigation process might not be terribly helpful. Think about Cooper against Aaron, the Little Rock case, right? This is in all the common law case books. Everybody talks about this is a high point of the Supreme Court's statement about the authoritative role of the judiciary in interpreting the Constitution. Well, it turns out that the case was not argued in the Supreme Court until just about a year after the Little Rock Nine actually entered school. In fact, by the time the Supreme Court rendered its decision, the Little Rock authorities had decided to close Central High School for the following academic year, and so those students who had not already graduated had to make other arrangements for continuing their education. Okay, now, but beyond that, I think that excessive reliance on the judicial process is a bad thing for the country. I think that litigation encourages parties to lock into positions that they take for purposes of litigation and leads courts, if they are going to make decisions on the merits, to draw lines that suggest that there are winners and losers, even if the legal rules that they come up with are multi-factor balancing tests. Nevertheless, when the court speaks, that constrains what the political branches can do. Now, as Professor Goldsmith suggested, sometimes that may be good. For example, when lower level executive branch officials tell the White House, we are not going to do certain kinds of interrogation because we think the law is inconsistent with this practice. And maybe that's a good thing. But it seems to me that in the long run, if the rules are less than clear, that gives the political branches, who are ultimately responsible for taking these actions, gives the political branches incentives to work out whatever accommodations they can. And that might mean that some people are going to, maybe a lot of people will take positions that are inconsistent today with the position they took 5 years ago, or maybe inconsistent with the position they're going to take next year. But nevertheless, those matters can be worked out. I also think that to the extent that we have any hope for interbranch comity in our political system, that those hopes are greater if we do not have people resorting to litigation to try to win every short-term battle. So my ultimate point on this, I suppose, is that the Constitution is too important to be left exclusively, or even in these areas, primarily to judges, and I think that's why we ought to be looking to the political branches to try to work out these accommodations. And if they can't, it seems to me that at least in part, we need, as the public, we need to see what we can do to increase the likelihood that some of those accommodations can be worked out short of litigation. Thanks.
Okay, thank you so much to each of you. Those who want to ask questions, please file up to the microphone, if there are any. Yes, please.
This is a very tall microphone. Great panel. Thank you so much to all of you. Sandy, I really enjoyed your remarks, and I was intrigued by your conclusions. And I have kind of a technical question here. I feel we haven't really talked about the international law of war at all, right? This has been a very inward-looking conversation about what the U.S. can or cannot or should not do. One of the things that came out of Hamdan and a lot of the case law was the idea that we're in a non-international armed conflict, which sounds a little strange because we are projecting power overseas, and so it feels like it ought to be an international, but there's this conception that it might be non-international. If that's true, the jurisprudence on this issue that we have in the ICRC position is that to have a non-international armed conflict, you need a certain protracted level of violence. There has to be a certain scope to, and it's because you don't want states, usually it's a civil war situation, and you don't want states using military force against a riot, right? You don't want to ratchet up the use of the laws of war in cases that are really just domestic conflict. So what do you think about that? I mean, I love the fact that you thought this war actually could end. I think the ICRC guidelines, the PICTAE, lots of the Tadich case would suggest that maybe it has already ended if we require a certain scale, intensity. My understanding from many of the people that propose the war will never end is that, in fact, there'll still always be one terrorist out there. So, without belaboring the point, when does it end? And maybe, Byron, you have an idea about that as well.
Okay, thanks. So I talked about sort of what are the factors that could help bring the conflict to an end. But sort of what is the characteristic of the end of this conflict in particular? I mean, people disagree on this view to some degree, but my sense has always been that when Al-Qaeda can no longer operate in the way that a state actor could have operated in a conflict type of environment, then you are getting close to what looks like an end. I mean, I've had colleagues in both administrations challenge the proposition that until the last splinter group that has become this umbrella puts down their arms, you could hold everybody, and you should, because they're a threat of some amorphous type. But obviously that gives me concern as someone who wants to preserve the tool of detention as a future tool that's necessary for armed conflict. So, I mean, it needs to be bounded in some way. And so my sense has been that the characteristic of the end is when Al-Qaeda can no longer operate on the global scale that it did to carry out the 9/11 attacks in the years following. And I don't think we're there yet. I mean, I think we're getting closer by the actions that have been taken, including, by the way, development of more international law that does travel bans, that puts people on terrorist watch lists, that freezes money and then allows you to do different things. So there has been a development of law that has helped in this big strategy. But as far as the NIAC discussion and the non-international armed conflict part of this, I mean, remembering that the domestic authorization by Congress is an authorization for use of military force that has no geographic scope. I mean, it doesn't say for the 9/11 conspirators and affiliates who operated in Afghanistan or operated in Pakistan. There's no geographic scope, I think, as many of us are familiar with. And so to the extent that this force that we have not yet been able to prevent from operating on a global scale continues to operate in other areas There has been a debate as to whether or not hostilities have to reach a certain level in each area, or whether or not the fact that, as we say, the flip has switched. We are in a conflict now. Whether that conflict moves around, the theory has been that you don't want to put geographic limitations on it because you will only encourage people to move to another safe zone and to bring the conflict further. So, I mean, I would argue that you don't want to have a geographic limitation in this type of a conflict. I mean, it's been characterized as a non-international armed conflict because it's a non-state actor. And to put too much geographic limitation on it is again, going to potentially, I think, allow the conflict to move in different areas where you can't actually go and rout out the enemy or try to stop it. So you know, it's a difficult issue, but I think you get to a better place if you try to keep it linked as one conflict that does have some end, and you define that end, and that ultimately, with all forces working towards it in all the areas where it goes, you probably have a better chance of ultimately sort of getting rid of the global scale in which it can act. Remembering, of course, that, you know, while it was once called a war on terror, it was never a legal war against all terrorist groups. It was a specifically defined terrorist set of groups. And so just because there will still be terrorists that come from what was once Al-Qaeda and the affiliates does not mean we will necessarily be at war with them, because we are not at war with lots of terrorist organizations around the world. So.
Maybe I could just add something. So I think the question of non-international or international armed conflict is an important and contestable one, and I think I probably disagree with Sandy's take on whether or not there should be geographical temporal limitations, which we probably don't need to get into now. So, for example, our position would be that in Yemen, if there is an armed conflict, it's a non-international armed conflict, and therefore United States citizens can't be targeted and assassinated. They should be treated as civilians unless they're directly participating in hostilities. But I think it just sort of raises a broader point, which is the law of armed conflict is contestable, and I think some people see it as constraint, like me, as a sort of humanitarian law constraint on what the military can do that comes from these, beneficent purposes to limit sort of killing and unnecessary harm and warfare. And others see it as license, and that gets us into a sort of even, I think, deeper observation that Professor Goldsmith makes, which was we now have these questions of justice that are incorporated in debates about lawfare, which is fairly novel. I just tend to think that in those questions about justice, in those debates about justice, typically the ratchets operate in a way that the law of war is seen more as license than constraint. And that worries me, and I think we have to acknowledge there may be some costs to that.
Hi, Ben Davis, Toledo. My question is relating to legitimacy and the use of the executive, legislative, and judiciary within the United States, the end result of all of that in terms of accountability. The question I have is to Professor Enton. On the one hand, these civil processes that have not gone very far, we can think of Al-Awlaki's dad trying to get a stopping of his son being killed and that basically being thrown out on early grounds. Now he's dead. I guess he could do a wrongful death now, but the idea was not to have his son killed, right? It seems to me that that's an effort of desperation, if I could call it like that, to try to stop the machine against my son, and not getting much of an answer from the courts. The whole discussion of Boumediene and the other cases in the lower court reactions there suggests that the courts essentially continue to do this deferential thing. With regards to Judge Hellerstein, with regards to CIA destruction of tapes, saying don't do it again, which is a clear action and contempt of his decision, is another example of sort of the courts in these, at least civil contexts, that seem to fail to provide a meaningful type of relief. On the other hand, on the criminal side, what I found was that we have had prosecution that's happened. If we can remember those soldiers who were court-martialed for what happened at the Uniform Court for UCMJ violations that we saw after Abu Ghraib. So the question I have is whether on the courts on the civil side or on the low-level soldiers on the criminal side, what is this inability we have internally to go up higher than those people? Or put it another way, do the military people just carry the water for the suit types in the CIA or in the executive, that they get prosecuted, but the people above them who set these things up don't? If you try to do it on the civil side out of desperation, the courts are not going to listen to you. And in the end result of all this is we have things that could appear to be lawlessness that happen within our system.
Well, I'm inclined to think back to, there's a wonderful classic article by Mark Galanter more than 20 years ago called, maybe more than 30 years ago now, called Why the Haves Come Out Ahead. There are, I think, some, I don't know whether they're institutional or political or what, but there are limits. There clearly are limits beyond questions, technical questions of procedure and jurisdiction, about what courts are willing and able to do, perhaps to some extent because what's the old saw, a federal judge is somebody who knew a senator, or, I mean, the whole system is limited in what it can do simply by a lot of its institutional features. And we might have different assessments of, say, Professor Goldsmith's suggestions earlier about what would have happened if there had been efforts to prosecute higher level officials for detention and interrogation. But whether Professor Goldsmith has it right or not, I think his view is certainly a plausible one, and that may have some bearing on what may happen as well. On the other hand, it seems to me, and this was part of what I was trying to suggest, even if we can't rely on the institutional legal system, the court system, there may be other sorts of political responses that may not satisfy all of us that we're holding people accountable, but that might cast a long shadow over future abuses. Again, reasonable people can disagree about the relative effectiveness of these approaches, but it seems to me that it's not necessarily an either-or proposition.
Anyone else want to add on that?
Sandy, I think you made a comment, and everyone else feel free to chime in on this as well, but that the comment was that no one in government wants to tackle the big issues in fear of criticism from the outside or potentially maybe losing their careers as a politician.
Maybe someone, but maybe not everyone. I don't want to say no one. I mean, obviously there are people, but I think that we do have a issue that's brewing where people want to govern more by consensus than by leadership.
Right, and I think in the 1980s there was a study done recently, but showing that in the 1980s the overwhelming majority of people in Congress identified themselves as moderate, whereas now in 2012 there are 0% of people in the United States Congress that identify themselves as moderates. What can we do to fix the problem, I guess this dilemma of most people just really being concerned with their own political careers or not wanting to tackle the big issues?
I mean, one thing that I think there needs to be more attention paid to it. I think very few people have gone out and sort of criticized the national security decision-making process for its slowness or indecisiveness, because obviously it's a process, and we like processes that allow everybody to be included and have their thoughts heard. And the reality is there is a merit and a value to that ongoing process. But in times of, national security imperative needs, I would argue there just needs to be a lot more attention to a president leading and directing, and in the absence of it, what you have is you have all of this space for, the political interest to oppose everything, and it comes back to who are you going to vote for next time around. So I think awareness is the first step. I think, people wanting their presidents to be decisive and to reward them for being decisive, not necessarily to always say, well, they should have gotten another opinion from, X, Y, or Z council. But I think we should go back to expecting presidents to lead, at least in times where our threat is at peril.
You see term limits in the United States Congress as being a potential solution?
I haven't really given thought to the impact of that, but it's certainly something that could be considered, but I don't have a view on that.
Let me just say, I think that term limits are likely to aggravate that problem. The experience that a number of states have had with term limits for state legislators suggests that a lot of legislators have a much shorter time horizon because they know they're not going to be there very long.
And I would just add that, the absence of moderation, moderates in general, I think gets exacerbated in a political climate where we're talking about endless war, because it's very hard to have a meaningful conversation where, have sort of national security and homeland security trump cards to play. And so I think reasonable minds can disagree, but I think some of the national security objections to what Obama's trying to do, like trying Khalid Sheikh Mohammed in New York, are kind of bonkers. But they're very effective rhetorically and consequentially. It stopped the action.
I have heard the opinion that the issues that we're discussing would be better off left alone by the courts. But I think that perhaps we're overlooking a big thing here, and that is that these issues are moral issues. That there's a question of what is right and what is wrong here. To do waterboarding, to do these renditions, to do targeted killing. Is it right? Okay, think back to the Dred Scott decision. It's not, well, we're going to lose this case. The Supreme Court is all for slavery, but is it right? Is slavery right? Is segregation right? Despite the drubbing that the integrationists took during Plessy versus Ferguson. So it's like, is there anybody that can address this as a moral issue?
Yes, let me. You have really broached a very difficult question when you say, is slavery right? Because all the defenders of slavery here are going to be offended. And if you take that as your model, then it's really straightforward. Let's always do the right thing. But let me go back to the example of our current vice president, a moralistic blowhard, if there is one, in public life. And he is just exulting that we killed Osama bin Laden. Now, take that example, which is a more serious one, I think, than what do we now think about slavery. Although, let me just say to the people of the 1850s, they all understood that the likely outcome of pressing that issue is what actually happened, which is a war in which almost 1 million people were killed. I mean, it was a very, very explosive issue because it couldn't be settled peacefully. When you can't settle things peacefully, you make compromises. When you get into a war, you do things which are unpleasant and difficult. And to come back to Joseph Biden and Osama bin Laden, I think a serious person has to be at least ambivalent about this. I mean, if the alternative was scrupulous respect for international law and he continues to be alive because we can't get into Pakistan or we can't get there without hurting people, I think most people think good that we went there, but maybe we shouldn't exult. Anytime you actually do choose to use force, you must understand that there's a likelihood not only that some people are going to be killed, but probably there's going to be some unintended casualties, and that's very painful and difficult. And for you to say, we must all be clear that we will never, never, never do something wrong. I don't know you and you don't know me, so we can speak freely and respectfully to each other. I just think it's a little bit, forgive me, it's a little bit childish. I mean, it's the luxury of academics. If I were a military commander, I would have trouble sleeping at night because I would be very reluctant to put my soldiers at risk knowing that it's extra risk for the sake of something that is a rather legalistic criterion. Now, I might think that I have to do it sometimes because I might think, which is a reasonable claim, that's what it is to be in uniform. You assume this responsibility. You have to take extra risk. But boy, I would find it extremely difficult. One of the excellent things about Jack Goldsmith's book is he has a couple of examples of this, of people like General Petraeus saying, these rules of engagement that were set up in Afghanistan were just too restrictive. And what that was really about was, well, we don't want to hurt innocent bystanders, but sometimes you will hurt innocent bystanders if you have to protect your own. That's a genuine, serious, real moral dilemma. And to say how many people are against slavery, it's just childish. It makes the whole thing trivial.
I'm afraid, while there are undoubtedly so much more that we could go into with this panel, we're going to have to end. So I want to thank the panel.
And thank the panelists and Avi and the questions that were fantastic. We're now going to take a 12-minute break. We will start right at 11:15 for panel 2,
Why it is valuable to have political
which is about the War Powers Resolution. See you in about 12 minutes.